2017 CF 15684, State v. Nelson, back from our lunch recess. Mr. Nolan, is the state ready to proceed?
We are good.
Ms. Moore, defense?
Yes,
Mr. Nelson, you ready?
Yes, Your Honor.
All right, Ms. Moore, why don't you go to the next issue in the proposed instructions?
Yes, Judge, the next proposed instruction is the heinous, atrocious, and cruel aggravator. So as to the sufficiency of the evidence, it's our position that there's not competent substantial evidence for this instruction to be admitted or given to the jury. Our position is that at best there is speculation that the victim may have realized that the defendant intended to kill her, and under the case law that is not sufficient for heinous, atrocious, and cruel. That in cases when you can't say whether the victim was conscious or knew of her impending death, that it's inappropriate to give this instruction. And my argument is supported by Zakruski, which I previously provided to the court. There's additional cases that go to this, which is Donaldson versus State, which is 722 Southern 2nd, 177, 187. I believe all of this is cited and provided previously in Hartley. Specifically, the idea that speculation that the victim may have realized that the defendant intended to do more than kidnap is, I believe, appropriate to the court's decision in this case. That comes from the Donaldson case. And in the facts that were elicited at this case, the only thing that we know, or how we know that all of this happened, comes from the defendant's statements. And according to the defendant's statements, she was alive during the time that he was driving to the ATMs and then ultimately out to the site where he left her. Further, during that time, there were statements in his confession to law enforcement that he told her that he wasn't going to kill her, that he told her he wasn't going to hurt her or rape her. There are indications that his statement was that once they got there, from the medical examiner's testimony, that once they got there, an exact cause of death can't be determined. Specifically, the medical examiner indicated that he could not say whether duct tape was applied prior to the stabbings or whether the stabbings happened first. He also couldn't say that the duct tape was applied prior to death. He indicated that, the medical examiner indicated that it could have been a spontaneous death if the electrical current of her heart was interrupted by the stabbing, and he could not say whether or not that occurred in this case. Additionally, he said that he at best could estimate how long she would have been conscious or how long she would have been conscious because she couldn't breathe or been conscious because she was bleeding. And at the best, he said minutes. I believe 5 minutes was the longest that he ever estimated. However, all of that is couched in the idea that he doesn't know which one happened first, and it could have been a spontaneous death. So I believe that the case law is clear that when it's speculation and you don't know whether the victim may have been conscious or not, that the heinous, atrocious, and cruel aggravator is not appropriate. Additionally, the court can't consider any factors that happened after death or lack of consciousness. That's clear in the case law as well, and these cases that I have cited and provided to the court in my motion. And because we can't say from the medical examiner's testimony what happened first or what order or how long she was conscious, I don't believe that there's sufficient evidence as to any of that. Additionally, in the Zakruski case, which I provided to the court, I believe it's the Zakruski case, it might be Donaldson, I'm sorry. They talk about specifically a victim being led out to a field where they're ultimately killed. And in that case, that was not sufficient for heinous, atrocious, and cruel because it was speculation as to whether that person knew that their death was impending, which I believe is factually similar to this case. Additionally, when I walked in this afternoon, there were a number of cases on my desk, which I guess are provided by the state. One of them is Bundy versus State, which is 471 Southern 2nd 9 from Florida Supreme Court in 1985. In that case, on page 15, the court says that they have to agree with the argument that heinous and atrocious and cruel cannot be proven when there's an absence of proof establishing the cause of death, that no specific cause of death could be determined from the autopsy reports, and there was no clear evidence offered to show that the victim in that case struggled with her abductor, experienced extreme fear and apprehension, or was sexually assaulted before her death. And absent these types of facts, we must conclude that this case does not fit in with our previous decisions in which heinous, atrocious, and cruel could apply. So in that case, they're saying that heinous, atrocious, and cruel did not apply because there was not a clear cause of death and because there was no evidence of a struggle, extreme fear or apprehension, or a sexual assault, which I think is consistent with this case where there's not a clear cause of death and there's no evidence of a struggle. Any evidence as to extreme fear or apprehension is speculation, and there's no evidence of a sexual assault. In fact, the testimony was that a sexual assault kit was done and that there was no evidence that it happened. So it's our position that based on the cases that I previously provided, as well as the Bundy case, that the state has not provided competent, substantial evidence of this aggravator, and so it should not be given to the jury.
Your Honor, I'm going to handle some of this argument.
Okay.
It's the state's position that there's substantial competent evidence to support a finding that the murder of Mrs. Fulford was done in a heinous, atrocious, and cruel manner. We are not asking the court nor the jury to engage in speculation, but certainly reasonable inferences can be made from the testimony and evidence produced in this case. Contrary to counsel's argument that we don't know what Mrs. Fulford's cause of death was, Dr. Stephanie clearly stated in the guilt phase and then when he was brought back during the penalty phase that in his opinion there were two contributing causes of death: the multiple stab wounds suffered by Mrs. Fulford, and because of the way that the duct tape was placed around her head and the manner, not just around the entire head, but the manner in which that was done, where it was tightly affixed to her nose and mouth, that those were both contributing factors to her death. Of note here is that according to the defendant, on the quite lengthy drive from Winter Park out to the Disney area, Mrs. Fulford was complaining that she couldn't breathe and that she was expressing her fear to him about whether or not he was going to kill her. Mr. Nelson selected this location it was for a particular reason, that it was out of the way of the flow of traffic, but his testimony essentially was that he marched her under her own power into that field. We know also from his statement that he had her basically had her hands, at least at that point, behind her back, and that when she realized where she was, she began to get louder and louder and louder, and that was the reason for his taping her head so securely. To prevent her, not only from, we would argue, from breathing, but to prevent her from making any sounds. Those facts establish a reasonable inference that Mrs. Fulford was aware of her impending death. According even to the case law that counsel has provided, the Zakruski case, and they provided also Guzman, 721 Southern 2nd, 1155, that in order for the heinous, atrocious, and cruel aggravator to apply, the facts must evince extreme and outrageous depravity as exemplified either by the desire to inflict a high degree of pain or utter indifference to or the enjoyment of the suffering of another. Additionally, and I believe Mr. Nunley had provided Finney to the court, but it's also quoted in Guzman, the HAC aggravating circumstance has been consistently upheld where the victim was repeatedly stabbed. Now, some of these cases also factor in whether or not a victim had defensive wounds, but we know that Mrs. Fulford was unable to defend herself from any of the stab wounds because Mr. Nelson had already had her arms tied behind her back, a fact that the state would argue makes this especially heinous. That as she was stabbed repeatedly after being forced to march to her own basic grave site, he stabbed her in the back and by necessity would have had to turn her over to accomplish what he had intended, which was to make sure she was dead. His statement was that he selected the midsection because he's familiar with anatomy, and then stabbed her repeatedly in the chest, and as we know, he stabbed her in the heart. Now, Dr. Stephanie's testimony when he was brought back during the penalty phase negates the defense argument here that we don't know, or it would be speculative as to whether or not Mrs. Fulford was conscious after she was stabbed in the heart because it could have interrupted the electrical circuitry of her system. I believe Dr. Stephanie's testimony was based on the placement of the stab. It was not his opinion that that was what had occurred. There was some discussion about the ventricles of the heart and that the placement of the stab wound did not suggest to him that it would have interrupted the electrical circuit, basically rendering her unconscious immediately. Therefore, we believe that under the case law and under the particular facts of this case, there's a reasonable inference that Ms. Fulford was well aware of her impending death and that the multiple stab wounds inflicted upon her while she was in a defenseless position was intended to inflict a high amount of torture to her.
Ms. Moore?
Yes, Judge, I would just respond to that. I disagree with some of the state's resuscitation of the facts, particularly the marching out to her death. I don't believe that that was established. However, all of what Mr. Nelson testified to in he also said he had been previously lying. So when the state is only relying on his version of events that he says are not truthful, I believe that that is insufficient and not competent substantial evidence. I would point to the case law that says that, particularly the Zakruski case, where in that case the medical examiner said that the victim may have been rendered unconscious upon receiving the first blow and as a result was not aware of her impending death. And that alone was sufficient for the court to find that heinous, atrocious, and cruel shouldn't apply. So the court is consistently finding that when it's not clear that the person was conscious for all of the attack or injuries, then heinous, atrocious, and cruel should not apply. When there's a question, even when she may have been unconscious, that means it's insufficient. In this case, while the state says that you know that she was conscious because she was taped first or whatever, the medical examiner has told repeatedly that he doesn't know what happened first and there's no way to tell. Mr. Nelson's testimony about that is all over the place. He's highly inconsistent about what happened when. And he's inconsistent in his statement to law enforcement, and he was inconsistent on the stand, and then those two statements are inconsistent with one another.
And Ms. Moore, your argument is, coupled with all the other evidence in the case, can't the inconsistency of your client's testimony allow the jury to draw an inference of guilt from that, coupled with all the other evidence in the case?
If that were the standard, Judge, then perhaps. But again, I don't believe at this point that we're taking the evidence in the light most favorable to the state. I believe the court has to make a finding that there's competent, substantial evidence, which means that the court has to make a determination on your own that there's sufficient evidence for the jury to make that decision. And the jury doesn't know the case law, and doesn't know that that the consciousness is important, and the court does. And so my point is that at this point, there's not sufficient evidence for a jury to make a legal decision that it's heinous, atrocious, and cruel, because there's not sufficient evidence that she was conscious for it. And there's not sufficient evidence that she knew of her impending death. The case law is clear that speculation as to either of those things is insufficient for heinous, atrocious, and cruel. And we can't allow a jury to make that decision based on evidence that only supports speculation.
So your argument is the only view of this evidence requires the jury to speculate.
I'm arguing that the view of this evidence with the medical examiner's testimony being that he can't say one way or the other whether she was conscious, and Mr. Nelson's testimony being entirely inconsistent, that legally it's not competent, substantial evidence for the jury to make that determination.
Ms. Moore, so what is your argument that if an expert or a lay witness says, I'm not 100% certain of something, that means that's can't be competent, substantial evidence to allow the jury to find? Nevertheless, we find that fact beyond a reasonable doubt. Not all doubt, but we've decided it's not a reasonable doubt. It's a speculative, imaginary, or forced doubt. We reject it.
Correct. That's not my argument.
Okay.
My argument is that there's not competent, substantial evidence of that, which is a different standard. And besides that, in this case, no one said 100% one way or the other. The testimony was that they don't know, and that it could have been this, but it could have been that. And that's consistent with the statement in Zakruski and the other cases where they're saying she may have been unconscious, and that's not enough for the jury, or if that statement is out there that may have been unconscious, that means that there's not competent, substantial evidence. And that's my point, is that there is the statement and there is the evidence that she may not have been conscious or may not have been alive for the other injuries. And because of that, the jury cannot legally make a decision as to heinous, atrocious, and cruel.
So, Ms. Moore, when you use the term competent, substantial evidence, and you don't believe there's competent, substantial evidence, is your argument that this is an impermissible stacking of inferences? Is that what you're saying?
Perhaps, Judge, but what I'm saying is that when the evidence is speculative, that speculation is not competent, substantial evidence. and the evidence here is speculative.
Isn't there testimony from your client that would allow the jury to conclude without speculation, if they choose to accept it? Well, let's set aside. Didn't your client say he stabbed her,
Yes,
in essence? So that's competent substantial evidence, isn't it?
not of heinous, atrocious, and cruel.
But is that testimony, does that meet your definition? I want to make sure we're on the same page so I understand your argument as to what competent substantial evidence is. Is that competent substantial evidence that the jury could accept that testimony? They could reject it, but am I understanding your argument that whether they accept or reject it doesn't change? It either is or it is not competent substantial evidence.
I think that when it comes to competent substantial evidence, the case law indicates that the court has to make an independent finding and that you have to determine credibility of evidence, that it has to be credible evidence in order to be competent substantial evidence. And so the evidence that the court has before you, just one statement in isolation, is not how the court makes that determination. So if Mr. Nelson said, I stabbed her, but then later said, I'm lying, the court has to consider both. You can't consider one and not the other. And when you consider both, it makes it not competent substantial evidence.
So is your argument that because there's inconsistencies in your client's testimony, the jury can't really consider anything he said?
No, my argument is that it makes it, that alone, that his testimony alone is not competent substantial evidence because he specifically said he was lying.
Is the jury free to believe or disbelieve his statement that he's lying?
Yes.
So they could find, in fact, he was telling the truth.
About lying or about what
About anything he said.
Yes, absolutely.
I mean, the instruction is all,
Correct.
part, or none of any witness's testimony.
I agree, Judge. Part of the distinction is that at this point, this is where the court has to determine that there's a threshold that has been met before a jury can decide if I believe part or any part of their testimony. And it's our position that the threshold hasn't been met because the evidence that's before them is not legally competent substantial evidence because it is contradicted not only by someone who's saying I'm lying, but also by the medical expert's testimony who doesn't have a dog in the fight, who is just interpreting evidence and cannot say anything other than it may have been this or it may have been that. She may have been conscious or she may not have been. And because the only testimony that she was conscious is specifically contradicted, that's not competent substantial evidence.
Well, why? Okay, I understand. I believe I understand your argument regarding the competent substantial evidence. What's your response to the state's argument that Dr. Stephanie's testimony about the time for unconsciousness to result from bleeding,
Dr. Stephanie's testimony was...
coupled with all the other evidence, if your argument is I have to consider all the evidence together to see whether it meets this competent substantial evidence threshold. And I know I'm isolating certain things, but what about your client's testimony plus Dr. Stephanie's testimony plus the other circumstances shown by the evidence in this case?
Right, and the problem is what part of Mr. Nelson's testimony, the part where he says I'm lying or the part where he says that happened. And in Dr. Stephanie's testimony, Dr. Stephanie, if we look at him in isolation, estimates if she was bleeding and that's what the cause of death is, then she could have been conscious for a period of minutes, not alive longer than 5 minutes. If she was suffocated, then she could have been conscious for a period of minutes, no longer than, I don't remember if he said 5 minutes as to suffocating, but all of his estimates were minutes. But then he comes back and says, I don't know which one happened first. I don't know if she even had duct tape on her when she was alive. And if the first stabbing, which he can't say what the order of is, If the first stabbing interrupted the electricity of her heart, it would be immediate death, then none of the rest of it matters. And because he can't say that that isn't the case, because all he can say is she may have been alive, she may have been conscious, she may have been bleeding, that's insufficient under the Zakruski case. Because he cannot say that she was, or it's my medical opinion that she was. He wasn't even able to say that. If he had been able to say that, then perhaps we'd be in a different place, but we're not. We're in a place where he says, I don't know. And I don't know is not sufficient. It's not competent, substantial evidence, even combined with Mr. Nelson's statements, which are all over the map.
Okay. All right. With respect to the defense argument that the evidence is insufficient to instruct the jury on this aggravating factor, I'm going to reject that argument for two reasons. One, court believes, having explored again with defense this competent substantial evidence standard, Ms. Moore has refined it a little bit more for the court. So I'm standing by my previous ruling, but now even considering this additional arguments, I continue to believe that it's really a JOA standard that would be applicable here. And I do believe that the evidence under a JOA standard is sufficient to instruct the jury on this aggravating factor. If the court is incorrect and the defense is correct, the proper standard is what the defense is terming the competent substantial evidence standard. I believe under that standard, as articulated by the defense, I believe the evidence here is sufficient. I believe there is competent substantial evidence, which must include all the evidence, not isolated, although we've talked about certain isolated pieces of evidence. It's all the evidence. I believe there is competent substantial evidence before this jury that warrants them being instructed. It's up to them to make the findings they seem appropriate under that evidence, but I believe there is competent substantial evidence to instruct the jury on this heinous, atrocious, or cruel standard. Now, with respect to this highlighted language.
Correct, Judge. That's an addition of special instruction that we're asking the court to consider. The reason that we're asking for that is that we believe that it's consistent with, or that there's evidence that supports that she may not have been conscious or may not have been alive when other acts were performed afterwards, that this is an accurate statement of the law, and that the instruction as is inadequate because it doesn't address this issue. One of the things I think is important is if the court remembers during jury selection that a number of jurors mentioned that if he mutilated the body or if he did something like that, that they would consider that and that that would be important to them in making a decision as to whether the death penalty is appropriate. The case law makes very clear that actions after someone is deceased, such as mutilating a body, are not relevant and not to be considered as to heinous, atrocious, and cruel. And so I think it's clear, we know from the record that jurors consider that, and that there's nothing in this instruction that advises them that they're not allowed to do that. And so that's why we believe that it's inadequate. This is an accurate statement of the law. It's coming directly from case law, and we believe it's necessary given the things that have been said and is supported by the evidence based on my previous arguments about the medical examiner and Mr. Nelson's statements.
Ms. Burdick?
No objection.
No objection to the highlighted language?
That's correct.
Okay. All right, Ms. Moore?
The last aggravator that the state is seeking is the cold calculated and premeditated aggravator. It's our position that there's not competent substantial evidence as to this aggravator. Let's start with, I would actually point to the state's closing arguments in the guilt phase of this, and for my argument here, the state, during their closing argument, essentially conceded the idea that this was a home invasion gone wrong, that Mr. Nelson testified to that repeatedly, and I believe that it was in the first part of their closing argument that they They said something along the lines of his intent was to get money and things went badly. In rebuttal, they even pointed out that a homeless person may need a knife. And so you can't necessarily rely on the fact that he bought this knife 11 days prior to the murder in order to establish that it was premeditated. So I believe that the state's argument essentially concedes the idea that the calculated or premeditated part here was the underlying felony. And the calculated or premeditated underlying felony is insufficient. It has to be the murder itself that is calculated or premeditated. I have cited to a number of cases in my motion and would argue that in Guzman, Gerald's, and Hansborough, the court talks about this heightened premeditation, that they look to the instruction on premeditation in the guilt phase and say that that's insufficient for the aggravator, and that the state has to prove more than that. In this case, I don't believe that more than that has been proven. The defendant repeatedly testified that his only intent was to get money, that he never intended to kill her until the last minute. He was consistent about that in his statement to law enforcement as well as his statement on the stand. Never once said that I intentionally planned to kill her from the beginning, that was part of his plan all along. He said repeatedly, my plan was to get money, my plan was to abscond, all of those things. With the only other evidence of premeditation in the case, other than Mr. Nelson's statements, is this shopping at Walmart the 11 days prior, which the state has even conceded that a man who is homeless may have needs for a knife that are not nefarious. And so without that fact, if you don't consider that fact, then all you have is the defendant's statements, and his statements are consistent that he didn't intend, that wasn't part of his plan, and that this was a home invasion gone wrong, which the cases are clear that a robbery or home invasion, those types of things that ultimately result in a murder, are not cold calculated and premeditated.
Ms. Burry?
Your Honor, as the court is aware, what counsel says in argument to the jury is not evidence, and so it's the state's position that having the defense support their arguments with things that were said in closing provides the court with no factual support to underpin their argument. The case of Pierce versus State, which was provided to the court at 880 Southern 2nd, 561, Florida Supreme Court case from 2004, quite neatly ties up the state's position in this case. It's actually at page 14 of that opinion, 14 being the printed page number, not necessarily 14 of the opinion. The first full paragraph says, this court has held that the execution-style killing is by its very nature a cold crime. As to the calculated element of CCP, this court has held that where a defendant arms himself in advance, kills execution style, and has time to coldly and calmly decide to kill, the element of calculated is supported. They go on to cite Knight versus State, 746 Southern 2nd, 423. Even if Knight did not make the final decision to execute the two victims until sometime during his lengthy journey to his final destination, that journey provided an abundance of time for Knight to coldly and calmly decide to kill. This court has previously found the heightened premeditation required to sustain this aggravator where a defendant has the opportunity to leave the crime scene and not commit the murder, but instead commits the murder. And then citing another case where it notes that the defendant had 5 to 7 minutes to withdraw from the scene, to seek help for his victim, but instead calculated to shoot her again, execution style. Now, typically, people may think that shooting in the back of the head is the only way to kill someone, quote unquote, execution style. The facts and circumstances of this case support that Mr. Nelson executed Mrs. Fulford. That he took her far away from the original scene of the crime, which was the home invasion kidnapping, for no other purpose than to dispose of her. And not only to leave her tied up in a field, but to leave her in a condition that most assuredly meant that she would die. Given that this case cites facts nearly identical to what we're considering here, the state believes that the facts and circumstances support a finding by the jury that this murder was committed in a cold, calculated, and heightened premeditated manner.
Any more?
Judge, I just received the Pierce case as well. I was just trying to look up the Knight case that it cites to see what the facts in that specifically are. And I'm looking and not finding, I could just have a moment. Judge, in my brief review of the Knight case, which is where the facts about the lengthy journey and all of that come from, I'm just not able to find quickly what happened. I will say in this case that there are two distinguishments from what Ms. Drain-Burdick indicated. First is that Mr. Nelson repeatedly testified that when he was driving, he still did not have the intent to kill her, that when he got to the scene, he still did not have the intent to kill her. So there's no indication, as this case said, that the defendant made the decision during a lengthy journey to a final destination. So there's no, that's contradicted by the evidence in this case. And in fact, Mr. Nelson says, I didn't make that decision. And additionally, in this case, it indicates that when it's citing to Alston, that there was a 5 to 7 minute opportunity to withdraw from the scene or seek help. Again, there's no facts in this case that support what the time frame was. I believe Ms. Drain-Burdick repeatedly tried to ask Mr. Nelson, and all he could say was, I don't know. And so without being able to find the specific facts of Knight, I don't believe that the specific facts of the state it's referencing are similar in this case. In fact, they're contradicted.
All right, with respect to the defense argument that the evidence is insufficient to instruct the jury, the court's going to reject that argument under either the JOAA standard that the court believes is applicable or the competent substantial evidence standard articulated by the defense. I believe in either case the evidence is sufficient to instruct the jury on this aggravating factor. Now, there's several highlighted paragraphs.
I guess the paragraphs below are in reference to doubling. So as to this instruction, it's just the one sentence.
Okay, I see that now.
In a prearranged design.
All right, go ahead.
Judge, so it's our position that this is an accurate statement of the law, that it is supported by the evidence in what I've previously stated, that Mr. Nelson repeatedly stated that his intent was to commit the underlying felony of robbery or kidnapping or any of those type of underlying felonies, and that his intent wasn't murder. So it's therefore supported by the evidence. And the other instruction is an inadequate, or the standard instruction, I apologize, is an inadequate statement of the law because, and particularly because the state went forward on a felony murder as well as a premeditated murder theory, it allows for confusion. Because the jury was routinely instructed that it doesn't matter if it's felony murder or premeditation before, I think it needs to be abundantly clear in this instruction that it matters as to murder, that it was premeditated, and to murder alone, that the underlying felonies are not what the premeditation goes to. And I believe that in conjunction with the previous instructions, that this is particularly necessary to make that clear.
Verdict?
Your Honor, we don't object to some instruction on this issue. We just object to the phrasing because this phrase could lead to confusion by the jury. It just doesn't seem specific enough based on the language in some of the cases that talk about CCP. Alternatively, we would suggest something more along the lines of what is required.
Well, let's do this. I'll give the parties an opportunity to draft something up, present it to the defense, and like we're doing with the other instruction that y'all are going to work out, and then we can revisit that.
Okay.
All right, Ms. Moran?
Yes, the next two highlighted paragraphs go to our argument regarding doubling. The first one is in regards to the commission of any robbery and the committed for financial gain. I believe the case law is clear that this is doubling and that we're entitled to the instruction. What's included here is the standard instruction. I will say that I believe that the court should consider adding an additional paragraph to the end that states that the jury should not take from this instruction that either of these factors deserve any additional weight. That weight is for the jury to decide. My concern, and the wording of that I'm open to, but my concern is, as I argued in the doubling motion, is that by allowing the jury to see that there are two separate aggravators for essentially the same conduct, it implies to the jury that that's a particularly weighty aggravator, that they should apply more weight to it. And I think that should be clear to the jury that just because it's listed here twice, we're now telling you to consider it once, but I also think there needs to be something as to weight. And my suggestion would be a sentence at the end of the paragraph saying that nothing from this instruction is meant to imply how much weight the jury should give this factor.
So Ms. Moore, with respect to the first paragraph that's highlighted but not underlined,
That is the standard.
setting aside that you argued that the state should have to elect, or it's rejected that argument. So you don't object to that being given,
Correct.
you just want it being given and then the highlighted and underlined as well.
Judge, two things. One, I want what's highlighted to be given, and then I want an additional sentence, what I just explained. The second paragraph is doubling again, which, but about the prior violent felony and being on probation, so it's essentially giving the instruction as to 2 more aggravators.
Oh, okay.
We are asking for that. It's our position that it is doubling. For the record, the case law is against us on that position, and we recognize that case law. We don't believe it's correct and believe that it should be considered improper doubling and the jury should be instructed.
All right, so going back then to the doubling instruction itself, you said you're requesting an extra sentence. Where's the extra sentence?
It's not on there, Judge.
It's not on
I
there.
apologize for that. It was something that I thought about over lunch, that because the court, consistent with the case law, agreed that they don't have to pick one or the other, I think that this instruction alone is insufficient. It's a standard instruction. And so I'm asking for a sentence at the end that says nothing about this instruction implies how much weight the jury should assign this factor. And the reason that I'm asking for that is that when we allow the state to list essentially 2 aggravators for the same conduct, it implies that the legislature or the court or whomever is saying, this is important, pay attention. And that implies weight. And so I think that it needs to be clear that this is one factor, and nothing about this instruction or any instructions that have been given suggests that it deserves more weight.
I'm sorry, you're saying it implicitly suggests it should be given more weight because of what?
Because when you are saying an aggravator in the course of it is an aggravator if this was done in the course of a robbery. And then you're also saying it is an aggravator if this was done for pecuniary gain. You're essentially telling the jury that both of these apply, which suggests to them that's important or that's more weighty. And I think it needs to be clear that not only are they supposed to consider that one aggravator, but that just because it's listed as 2 doesn't mean they get more weight.
Okay. Ms. Burdick?
I think the instruction implies just the opposite, that there are 2 different aggravating circumstances that apply, but since in this instance they are based on the same conduct, you can't consider them twice, you can only consider them once as one potential aggravating circumstance. So the standard instruction does the exact opposite of what she mentioned.
Ms. Moore?
Judge, I believe that this standard instruction is an attempt to fix that problem. My position is that the standard instruction doesn't do enough to fix that problem. And that's why we're asking for an additional sentence that says nothing about this instruction suggests what weight should be applied.
All right. I agree with the state. I believe that this instruction adequately addresses the doubling issue. I've read this instruction. I'm hearing the defense argument about the implicit suggestion, and the defense is being candid that their argument is implicit because it's clearly not expressed, that they are to weigh these factors any differently than the other factors, except I would agree with the state that by saying that they're merged, I think if there's any implicit suggestion at all, it's that they're less weighty than the others. Although I really don't agree with that either. I think it's really clear and unambiguous language that has been used to address this merger, to address the doubling issue. And looking even beyond this, at the remainder of the instructions, I don't see anything that suggests to the jury how they are to weigh any particular factor, including but not limited to any factors, aggravating factors that are subject to the doubling instruction. So I'll reject the defense request for that additional sentence. What's the state's position on the doubling instruction with respect to previously convicted of a felony and on felony probation, and previously convicted of a felony involving the use or threat of use of violence to another person?
Your Honor, as counsel stated, the case law from the Florida Supreme Court is against them on this issue. We provided copies of those cases, which are Bundy, which you referenced earlier for another issue, 471 Southern 2nd 9 from 1985, Hildwin, Hildwin, 727 Southern 2nd 193 from 1999, and DELAP, DELAP, 447 second, 1242 from 1983, that there's no improper doubling if a jury finds that somebody in these cases was under a sentence of imprisonment, but that the felony probation had been added after the dates of these opinions, and a felony involving the use or threat of force. These cases say that there is no improper doubling there.
And Ms. Moore, is there any change in the case law or something supports a good faith argument regarding a change in the existing law on this issue?
Judge, there is no change in the law. It's our position that factually it results in doubling in this case, and so the court should give the instruction. But as I said, I do recognize the case law is against us. We just disagree with the case law in this case.
All right. So the court will deny the defense request for the doubling instruction with respect to the previously convicted of felony probation, and the previously convicted of a felony involving use or threat of use of violence to another person. All right, Ms. Moore.
Judge, the next highlighting is by the state under the mitigating circumstances. I believe that those are appropriate. We are asking for mitigating circumstances 2, 6, and the catch-all.
We'll just renumber those as 1, 2, and 3.
Renumber them 1, 2, and 3?
Yes.
Judge, on the next page where it's highlighted in blue, Mr. Lara is going to address that issue. He filed the motion on that previously.
All right, give me just 1 second. So going back just briefly to the yellow mitigating circumstances, the state's saying those will be renumbered. So as renumbered, then the defense does not object, correct?
Correct. Those are the ones we believe are appropriate.
Okay. All right.
Judge, just before the court moves on, may I approach the clerk? Ms. Simmons put my last argument regarding the doubling instruction in writing, which I believe is appropriate under the law, but so I just would like to file this. You're saying the court's already denied it?
Sure. Okay. You have a copy for the state?
Gave it to
Okay.
the judge.
All right, great. Anything else on that, Ms. Moore?
No.
All right, Mr. Lar?
Yes, Your Honor, we're requesting a proposed jury instruction on mercy. I think the court received the prior case law that I sent last week regarding some of the cases in Florida and the U.S. Supreme Court basically say that mercy is a allowable constitutional consideration for a jury to make. But what I want to draw the court's attention to is the problems that we have with current instruction and the in-rate standard jury instruction in criminal cases, report number 2005-2, which is located at 22 Southern 3rd 17. The Florida Supreme Court set forth some of the standard instructions, and what they decided to do was include a phrase that they believe would be sufficient for a mercy instruction. And it says neither compelled nor required to recommend death is something that is addressed to the jury. And in fact, they refer to it on page, I want to say 13, but on line 4 of 15. They say we declare many times the jury is neither compelled nor required to recommend death where aggravating factors outweigh mitigating factors. And they go on to further quote the Gray decision in Gray versus Georgia at 428 U.S. 153, that a jury can constitutionally dispense mercy in cases deserving of death penalty.
Slow down.
I'm sorry. That the jury can constitutionally dispense mercy in cases deserving of the death penalty. The problem is it doesn't specifically say mercy, and in that case, therein lies the problem. And what I
Mr. Law, I'm sorry to interrupt. What I have in blue is underlined as if that's additional language that's not part of the standard. Is that correct?
That is correct.
Okay, but then you referred, I believe, in your argument that there is somewhere in the standard what the Supreme Court believed to address this concept. Where is that in the 7.11, if that's where you're referring?
That is located, and so I have that highlighted.
I mean, maybe it is later on. Actually, I need to take Mr. Law, I'm sorry to interrupt, but I need to take just a brief recess, so why don't you look for what you're going to find, and then we'll come back and we'll discuss it. All right, we're going to take a brief recess.